Good afternoon. I'd like to welcome everyone to the AIPRA and Family Trusts. Our presenters today are Casey Ross. She is with the University. She's the University General Counsel for Oklahoma City. And Jim Wabindato, Little River Band of Ottawa, is with ITLF. Thank you. I would like to remind you that we have a sign-in sheet. If you'd like to claim CLE credits, remember to sign in before you leave today. Thank you.
And one other thing, as we go through, this is going to be a discussion as much as anything, because it's a new project. So as we go through this, because it's being recorded, let us get over to you and get the microphone so it will be recorded for posterity. The Indian Land Tenure Foundation had been working with a couple of federal officials about 5 years ago and talking about what could be done to improve land management opportunities. I happened to start about 5 years ago and opened my mouth and talked about this problem I was seeing with my in-laws' property at the time, that their father had enough foresight to grant specific parcels to each of his children, and it avoided fractionation. He had worked at the Bureau, so I'm convinced that he knew what the issues were going to be, and he did that. But as we've looked at the next generation, my daughters, my nieces and nephews, I was seeing that fractional ownership is something that might come up. The family uses the properties in a very communal form, and I thought, well, geez, if you're off the reservation, there are so many different ways you can deal with joint ownership of properties, but in Indian country, there doesn't seem to be a way to do that. So of course, like I said, I mentioned this to one of my colleagues. She forwarded to me to Chris Stainbrook, our boss, and he said, great, Jim, we've been talking about this. Guess what you'll be doing? And so for the last 4 years, I've been working through this project. And the idea is that the American Indian Probate Reform Act allowed the pilot of a project to, as you can see, for individual landowners to come together as co-owners and use some formal organization, some legal entity that would manage the property for them. After having those conversations, we pulled together a development team that looked at how this might look for the foundation to sponsor a project and start meeting with families, go through the process. When we got into the administration of the project, I was working with families, and it was harder to put together something that didn't have a roadmap. Families had a hard time understanding what we were trying to describe. They kind of had an idea of what it might look like on the end, and without a clear roadmap on how to move ahead, we lost a lot of families who thought, well, geez, without knowing what to do next, it was going to be too much time, too much effort on their behalf. And as we continued through that process, we did find a number of families that came together and felt that it was going to be still a valuable way for them to work and manage their Indian land. What you had in your bags when you arrived was this Message Runner 9. This is a culmination of that effort so that we could put it into plain terms on how this project could look, what we should do to move the project ahead going forward, and provide information for landowners, for tribal land staff, and for federal officials on what this might look like. The format that we're using today is to go through some of the specifics through the Indian Land Consolidation Act language, go through a little bit of what the experiences were like for some of the families, but I wanted to give this to you so that you could help me better understand how this could work for your tribal communities as well. Casey has been part of this development since the beginning. We had her as part of our advisory committee, and she has accompanied me on a couple of different presentations as well. So she will work with us. I'm used to being on the back end of things, and so being the primary presenter today, I didn't think forward enough to actually have copies of these, so they're being made right now, and once we get that, I will be able to get them in your hands.
So I'm excited to have this roundtable discussion today because this project is just a little bit, ill-defined, okay? So like the language, which we're going to talk about, authorizes something, but it doesn't really describe what that something looks like. So while that does present challenges, it also presents opportunities, right, for us to kind of develop a structure that makes sense, that we think would actually facilitate what the purpose is, to basically make the management of land less onerous and more productive and more impactful. So I think once we kind of talk about just the basics of the statute, we can spend some time talking about different models that might work for different families or different tribal communities. I'm excited to be here with you guys this afternoon. I know it's after lunch, but we're going to power through. Okay.
And it's very difficult to follow after lunch because I think we all kind of have that sugar crash. So as I mentioned, I'll start with the code. So 2206 of the Indian Land Consolidation says that the Secretary shall consult with tribes, individual landowner organizations, Indian advocacy organizations, and other interested parties to develop this pilot project for the creation of a legal entity such as a private or family trusts, partnerships, corporations, or other organizations to improve, facilitate, and assist in the efficient management of interests in trust or restricted lands or funds. But it doesn't exactly make our jobs as land professionals and landowners very easy on the flip side. So as I was going through this, my instructions from the boss were that we do it in a way that reflects the needs and desires of landowners. Build it from the ground up in a way that helps to advance land management and land ownership. And from that experience, we would suggest to Interior what those regulations might look like. So at this point, again, it still becomes very easy for us to define what this is going to look like. How many people have had a chance to look at the message runner and see how this project was put together? So we've got one individual. All right, so we'll go through this because this part is the driest piece. It's going to be so difficult to get through, in my estimation, because it's just U.S. code. Transactions would still have to go through Interior, and that's one of the things that I think we'd like to see changed. As we were working with the advisory committee, they wanted us to develop tools that would be flexible and adaptable. I think that's one of the hardest things when you're looking at federal regulations is they want to be very concrete, very specific on what's going to happen and what should happen as you're doing transactions, doing approval processes. But again, as landowners, we recognize that constraint may be easier for the Bureau, but it's not very effective for us. It makes it very difficult to enter into a new lease or to perhaps put together agreements that help a business move ahead because you're stuck working through this formal structure. And most of the families I was talking to, their issues related to knowing what they wanted to do but not being able to do it very effectively or very efficiently. I think in the end, we had conversations in Oregon, Idaho, Montana, South Dakota, North Dakota, I think Oklahoma, Arizona, and that was pretty much it. It was a number of different tribal communities, a number of different opportunities. When we were talking in the tribal communities, one of the pieces that would need to be in place, and that's why I wanted to share it with you guys and get feedback, is that the tribal government would need to put together its own processes for these organizations to exist. Right now, one of the families I worked with, they created a co-op, but they formed it under Oregon state law. Now, when you look at this from a long-term perspective, it's not exercising the tribe's sovereignty, it's not kind of buying into the full system, but it was expedient. They were able to get their co-op put together, they were able to start getting grants for their feasibility studies and different development activities. But in the long term, I think this is where we need the tribal leadership to see the value of this project, this kind of an idea moving ahead in their community. I'm trying to think. What's important from the beginning? Any other things?
Maybe examples about different structures would be good, like different
Oh, sure.
options for people.
In the publication, we put together the main primary membership and landowner associations, nonprofits, for-profits, co-ops. Power of attorney and section 17s. They are in the bag. I don't think everybody brought their bags with them. And so it really comes down to looking at how you would do this, from the easiest being power of attorney, all the way through the most difficult, which would be a federal chartered corporation. Ideally, these need to reflect what the family wants to do. So when she's talking about examples, the co-op was a way for associated cousins to take 4 adjoining 160-acre parcels, put it together for an economic development opportunity that would be 640 acres together. At 640 acres, you actually have the ability to start looking at economic scale. When you're talking about 40 acres, unless you have that immediately accessible to highway and to regular traffic patterns, it's going to be difficult to deal with. The family I was working with at Muskogee Creek Nation, they had 7 brothers and sisters. They have fractional ownership of their grandparents' land, and there are about 6 or 7 parcels that make up what they got from their grandparents. So as they're looking at the project like this, that's one family looking at multiple parcels, and how do they use that? You know, they were telling me when I was visiting with them in November that they grew up picking rocks and tending to the potato fields. And that actually was funny because they were talking about the fact that the grandkids haven't had that experience, and they were going to have to start putting that in front of them so that they would, know the importance of the land to the family and how that ties them back to their community.
Can I talk about that
Absolutely.
for a second? I'm going to use this. So one thing about that family that was really interesting, right? So you've got some, different interests in different parcels of property, but you're not seeing like a 100% interest held by any individual person in the family. And when we were talking about, kind of in our early days of discussing this project, we were talking about different structures that might work, right? So like some people might want to be super formal and go file like a separate corporation, right? They might want to go file as a corporation and create a structure like that. Others might want to have something more like a loose association, right? That would be bylaws and things that they came up with themselves about how they would govern each other. So what was really interesting about this family is, even though there's not a set up structure under the act, even though there aren't regs that set up a structure, they had already figured out what was going to work for them. The family had already done it. And you guys, they have like a family meeting, right? Like once every quarter, and they come together and it's potluck and everybody eats and everyone visits and stuff. But then when the meeting's supposed to start, the meeting starts and they have an agenda. They call it to order. They use Robert's Rules of Order to talk about the different things that are impacting their property. So it was a very interesting organization that they did themselves. They didn't wait for Congress to authorize it. They didn't wait for regulations to tell them how to do it. They said, as a family, excuse me, this is how we want to manage our property. And they've done it by agreement, right? They've done it by agreement with one another to manage property in a way that is strategic and in a way that's coordinated with one another under this structure that they set up. So it's an easier sell, right, to go to Congress or to go to the department. It's not something we're asking you to create. We have examples of families who have already had to figure out and navigate ways to do things with property as a group effort rather than individual interests. So I just thought they were really fascinating there. I couldn't believe that after everyone had lunch, it was a meeting that got called to order. It blew my mind. I've never been to a family lunch like that, but it was really cool to see. It was very, very formal. Very cool. Sorry.
Oh, thank you, Casey. I have a standard presentation, so that's why I'm kind of a little uncomfortable. It's like, well, do I talk about this, talk about that? When I talk with families, so the key thing that I learned while doing this process is that it talks about putting regulations in place for families to manage their land. But the irony that I found is that families already can do this. They don't need enabling legislation. As Casey pointed out, the family realized, we're going to do this, and it's about management, so there's really no reason for this process to be held up. I think one of my visions for this project in the long term over the next, say, 10 to 25 years is that we create a new class of Indian landowner, and that landowner would be a corporation or a nonprofit. It might be some activity that allows the family to bypass the management issues, to bypass probate, to allow us as Indian people and landowners to do the things that our relatives across the street do on our reservation because it's non-trust land. And so as we go through this process, it's certainly going to be very important to, like I said, have the enabling pieces available to us through the tribal government. I think when I look at this process and the project together, what I saw was that we need to go to Interior and basically force their hand for us as landowners to put together these, like I said, for-profit corporations that are going to maybe build housing that then we rent out or sell out to others in the community. As we look at doing that, it becomes critical for the tribes to take a leadership position. So that's why I wanted to share this with you guys, to go back into your communities and advocate that the leadership look at this as a tool for land management. Because when you look at the big picture, I'm Little River Band of Ottawa Indians. My tribe asserts that to be a citizen, we have to be 1/4 blood Indian Quantum. My daughters are enrolled with their mother's tribe, which is the Bad River Band of Chippewa. Well, at Bad River, they're lineal descent. As long as you get enrolled at birth and you can prove that you're a descendant somewhere of the Bad River Band, you can become a citizen of Bad River. And each of our communities has that inherent authority. Interior already recognizes that ability to define who our citizens are. And when you look at the Supreme Court, you look at the state of Minnesota, you look at any state, they allow corporations to have a lot of the inherent rights and opportunities that we as corporeal beings to exist for these corporations, for these nonprofit entities. And so my perspective, and what I would like you guys to buy into as well, is that we can get our tribal councils, we can get our governments to recognize these corporations as part of the body politic in our communities and use that as a vehicle to, again, force Interior to recognize that just like in Minnesota, this corporation is a legal entity. It is rights of land ownership. It has rights to conduct business that's legal and other activities. And that becomes the vehicle that I see us using to go ahead with that. I'm trying to think. I do have a presentation I can show. Let me think. Oh, here we go. In organizing the family members and co-owners, it really comes down to what is their overriding organizational level. So are you talking about a specific parcel of land, Are you looking at families like the Creek family in Okmulgee coming together and looking at all of their separated lands working together? Or like the folks in Oregon who put together a consolidation corporation to behave in a way that allows 4 parcels to work together as one? Again, kind of looking at this least complex is power of attorney, association cooperatives. Like I said, each of these is something that can already happen, but without the tribal participation, any of these are going to be formed under state law. And again, I think it becomes a much harder sell for Interior to do the project.
So is that how to make decisions about the property then? Is it, are you forming a corporation?
I guess my question goes to how are they making decisions? You indicated before that all the owners got together, implemented Robert's Rules of Order. So if there's thousands of owners, which is possible, do you take a vote? Do you just set up a corporation? Do you have some sort of board to make those decisions?
So I think all of those are options, right? So I think really at this point, the idea is to think through what all different types of approaches might work. And ultimately, I think what would be most helpful to families or to groups of owners who are looking at something like this, what I think would be most helpful is to kind of walk through what each of these looks like under the law, but to also, hopefully the Indian Land Tenure Foundation can provide some technical assistance, but I think even providing them some sample bylaws, operating agreements, whatever's appropriate for whatever structure they pick, that would set forth kind of how things work, right? So if we went with just a power of attorney, the power of attorney document could set forth exactly what types of permissions have to be secured from the individual who's granting the power to the attorney in fact. I mean, you could put the meat of that in a power of attorney agreement. You could also put it in the bylaws of an organization. You could put it in the constitution or the operating agreement of a partnership. I mean, there are a whole lot of different ways to set that forth. And I don't think that it has to be the same for everybody, right? So for some families, it may be we're going to delegate the authority that we would have had to make decisions on our property to this other person, and we trust that person to make the right decisions. For some families, it may be we need at least 51% of us to vote in favor of that action before it can proceed. Other families may say we want 100% yes votes before it can proceed. I mean, there are all different ways to do it. It's just a matter of figuring out organizationally what people want and then providing the tools so that they can paper the things up the way that they need to be papered up. So when we talk about needing tribal law to back up these entities, right? When we talk about wanting to go out and actually incorporate an organization, when Jim mentions that, from a tribal perspective, we need to see a buy-in there. He's really talking about tribes as a matter of their own tribal law, passing codes that actually set up entity formation, right? Not all tribes have those. We don't have the ability to go incorporate under our tribal law in a lot of tribes. And so what ends up happening is people go and incorporate under state law. That becomes just a little bit glitchy, right? When we're talking about a federal trust relationship. So I'd say that's one of the things we need to work through. We need to think about how legal entity formation may or may not be impacted depending on the choice of law. I think another thing that we need to think through is we need to make sure that whatever we do with this, whatever one of those options we pick, however things get structured, whatever we do, we need to make sure that it in no way diminishes the trust responsibility of the federal government. That has to be always something owed to American Indian people. So as one thing that I was a little bit worried about whenever we were having these kind of first sit-down meetings at Interior about this project, one thing that I was kind of worried about was I didn't want this to be an opportunity to have the federal government seen as stepping out of the trust relationship, right, as to a particular set of properties. So I think that's another thing that we need to be really cognizant of as we set up structures. We don't want to set up any structures that are going to impact in a negative way that trust responsibility, and we don't want this organizational structure to change the way that trust responsibility is seen.
And one of the Because this is our project, I had the ability to cherry pick who we were going to work with to the degree that I think this family was one of the bigger ones. I worked with a family at the Confederated Tribes of Umatilla Indian Reservation. That family, I think we had about 18 to 20 people who showed up at their largest meeting. So again, it was kind of on the smaller scale. So as you get into larger organizations, to reflect the needs of 150 or even 500 landowners, you're probably not going to look at a corporation. If you do look at a corporation as the best solution, you'll probably need to set up a board of directors, have shares in essence for how those people will represent their interests at a grand scale so that it becomes efficient and effective to move ahead on a project. I would also see a landowner association probably being an easy way to approach that. For instance, at the San Javier Reservation in southern Arizona, part of the Tohono O'odham Nation, they had farmers and ranchers who had difficulty accessing the water. The river went right through the reservation, but of course in the Southwest, as non-Indian communities were starting to divert that water for their own use, they had to fight to get that water rights back. And so it created a prolonged court case, and through that process, it actually successfully created two organizations. They have the San Javier Agricultural Co-op, and then they also have the San Javier Alati Association. So the Alati Association represents everybody, whereas the agricultural co-op actually is owned by all of the landowners who are in the area that is being farmed by the community. So that's how they have approached doing this, and they formed their entities under tribal law. So actually, like I said, for management purposes, this stuff is already happening, but it's not very well known outside of our tribal land offices and those who are actively working in some of these projects on a regular basis.
It's also, so it's not just that it's not really well known, it's also just not recognized as an appropriate land management vehicle by the Department of Interior yet, because it's just authorized to be piloted, right? So it's not like Department of Interior is going to look at a family like our folks at the Muskogee Creek Nation and say, okay, we're going to deal with the one person who's communicating the decisions of your family meeting, right? They still consider the individual interest owners as fully authorized to engage in transactions on their own property subject to this federal approval. So it's not something that has yet risen up to the level of the department recognizing it, because it's just so new, right? It's just such a new iteration of a different kind of approach. I will say, when we think about putting these types of things together, one concern that we need to think through, and we probably need to have some discussion about, is dispute resolution, right? It's not that all families are going to always agree and get along with each other when it comes to this type of stuff. And because that is a high potential, right? It's a high potential for conflict if people disagree with things. There needs to be an understanding of how those types of disputes can be resolved. And again, that's something that can be incorporated into the organic documents of whatever structure the group goes with. But I do think it's something that Interior is going to have to also kind of understand and play by those same rules, right? Right now, you've got groups that just do it harmoniously, right? They're just doing this because the family agrees on it. But what happens when the rubber meets the road and there's a disagreement in that family, right? If we have something that's bubbled up to the level of Interior operating with an entity rather than individual interests, the department has to understand what that dispute resolution thing looks like and not interfere with that dispute resolution thing, because it needs to be part of the overall structure of the thing. So that was another thing I was thinking of. Now I'll stop.
Do you guys have additional questions before we move ahead? Oh.
Jim, thank you. Bill Tovey, Umatilla Tribes. And I've worked with Jim and my family, and so there's my mom, and she's in her late 80s, and there's 3 brothers, and so we all get along pretty good. We golf together, so it's But the thing I'm looking at, would be very easy to set it up that way, but there's no governing law. But the tribe has an LLC code. Is that something you could put in place pretty easy, first off? And then how would then working with the Bureau, they'd still look at you as individual lottees, not as a group.
I think you're right. I think that's why we have the work to do to kind of get it buttoned up. Because when we're talking about like right now, today, right? Sure, you can form an LLC for any lawful purpose, right? But is the department going to recognize the authority of the LLC to deal on behalf of all of those individual landowners? The answer today is no, right? But we want to develop these different avenues and these different options and get them in a position where the department does recognize them, so that tomorrow, whenever you go and file for your LLC, the LLC can actually go and represent the interests that are conglomerated under its organizational structure. That's the whole purpose of this.
Yes, and in fact, actually, most of the tribes that show up in my research as having enabling legislation allow for creation of LLCs specifically. My tribe, the Little River Band of Ottawa Indians, has an enabling legislation for LLCs. But as Casey points out, there are other entities that we should be allowing for. As a nonprofit, you're actually talking about two different things in that respect. A nonprofit is a corporation. The nonprofit status is actually something that is negotiated with the Internal Revenue Service. So as you're looking at this, taxation is another issue that we would need to go through Interior to the Internal Revenue Service and have IRS start to recognize that these entities are part of the tribal body politic. As many people might recognize, if you're doing agricultural activity, if you're deriving income directly from the land through growth, internal IRS doesn't tax those activities. But if you build a hotel and the hotel starts to charge guests, well, both the state and the IRS become interested in what you're doing, and they want their fair share. I have personal issues with states coming into reservations and taxing, but that's a whole nother conversation. Ultimately, that's where this ownership is going to be something that has to be addressed in the long term. As long as we're looking at these entities becoming the owners of the land, it becomes much clearer and much cleaner to set up all the supporting structures legally for that activity to take place. As you point out, if the Interior is still looking at you guys individually, even though the corporation is supposed to be acting on your behalf, it muddles things up. It makes it very confusing, not just for them, but even for you guys. And that's why, like I said, when we're looking at this, tribes will have to see what makes sense for them culturally and legally so that this can happen in a way that is productive for the landowners. And as I continue talking to landowners over the next, say, 3 or 4 years, I'll also begin to incorporate conversations with tribal leadership and tribal council or tribal governments so that we can start putting those pieces in place. Like you said, Umatilla has the ability to form an LLC, but that might not be the right thing for what you're trying to accomplish. But if it's all you've got, then you're going to have to be stuck with that. And so that's responsibility of the foundation to clear the pathway. But until we hear stories from landowners, we don't know what those solutions need to accomplish necessarily.
That's really where we got kind of hung up with Interior, was trying to figure out how to get Interior to deal with an organization rather than individual interest owners who were members of an organization, right? And we talked a lot about transferring title of the property out of an individual's name into an organization's name, and talked about wanting to make that a mechanism that was available. Obviously, it's brand new, so it freaked a lot of people out, right? It's kind of freaky. But at the end of the day, I think that is the best way, right, to effectuate moving forward with something like this. But again, what happens when you're dissatisfied with how your corporation is handling your interest? Are you going to turn to corporate law, right? I mean, you are. You're going to turn to corporate law to make a determination about what a member's rights are, what a shareholder's rights are. Can you just take all your stuff out of the corporate ownership and go home? No. I mean, so there are a lot of different things to think through structurally in a corporation as opposed to an LLC, as opposed to a partnership. And it's going to be fact intensive and case by case specific about what's going to work best for whatever group of folks is coming together to conglomerate property interests.
And we've gotten very heavy in the conversation right now, we're getting very heavy into corporate law and bylaws and a lot of these things. And that's something that I think the tribal governments will need to think about very hard, is how complex does it need to be to reflect, the management and oversight over these entities. At the same time, each of our communities have different cultural perspectives on our relationships to each other, and again, dispute resolutions. And so I could foresee this actually having a different face depending on where we're actually working. The project itself is designed so that we can create space for these conversations to continue, for families to tell us what's important for their ownership and management, for tribal governments to tell us how they feel these relationships should be conducted. So much of what I did when I got my real estate licenses had very little to do with the knowledge I would have to do a real estate transaction. So much of what I had to learn was how to operate under state law so that I'm not violating the consumer's rights and opportunities. I mean, so like I said, becoming a real estate broker in Wisconsin had very little to do with running a real estate brokerage company. It had much more to do with making sure I wasn't screwing over people who wanted to buy and sell houses. For his attorneys, I'm sure it's primarily about customer protection as well.
Yeah, lots of things to think through. So since this is a roundtable, are we done with our presentation part and maybe start getting some comments and feedback? This is what I'd like to know, okay? When we're up here talking, okay, so we've gone to a lot of meetings, and when we all get together and talk about this, like, all of us people, we're all really excited about it, and we start like coming up with ideas, and we write things down, and we think, okay, that's something we need to go look at, and then that's something we need to go look at. Like, we get just really excited and crazy about it. But then when you go talk to like the Department of Interior about it, they look at us like we're insane. Like, they're looking at us like, what are you talking about with this? And I think it's just a lot, and it's kind of inside. So when we're explaining this, when we're describing this, does this sound like something that is cool and interesting and something to maybe look into? Or are you thinking, yeah, this is a mess and nobody needs it? How many of you think interesting, maybe we'll keep looking at it? How many of you think total mess and not helpful? And then how many of you just don't vote because you're anti-voting? It's okay. I get it. So it's really something that I think we can have some discussion about in here. But I'd really like to hear if you guys have any ideas or questions about different structures that might work. If you can think about landowners in your area and things that maybe they could achieve if they were represented by an organization rather than individually, right? Because that's kind of the overall goal of the project. But if you could kind of think about that, we could just have maybe some roundtable discussion about ideas or questions. I think that would be a good way to round out.
I'm struggling a little bit because the tribe that I work for doesn't have individual landowners. The closest we come is to there being original grants of lands to certain families. But it's still treated throughout the constitutional structure of the tribe. So the only interests individual members have in property are to the assignment that they're given to build a single-family house, and the lease that evidences their ability to use the single-family house. I find it interesting because as a long-term planner, economic developer, more so than an attorney, one of the concerns I have long-term is how do you keep the members of the community entrepreneurial? And how do you give them other structures in which to operate other than those that are prescribed under Minnesota law? But I'm struggling to see how it fits into this tribal context.
Okay. So I think the land base that you're describing for the tribal community yet another example of there already being a different model than what Interior kind of sees as individual landowner rights, right? I mean, I think that's a good example to take back and say, this is how this is structured and this is how it works, because that in and of itself is a more simplified approach to management, right? But yeah, I think it does create a whole lot more questions than answers at this point, just because it's so new. I mean, we're talking about a pilot project that's authorized and I guess kind of underway, right? But I think those are all things that we just have to talk through and consider.
The other thing with what you're talking about is the fact that you do have one landowner. This was born of a way to deal with fractional ownership. And so yours is an elegant solution, but it's because the tribe is the beneficial landowner.
That's probably true, and let me confess to two things. First of all, I'm not a tribal member, and secondly, I spent most of my however many decades in the public sector outside of tribal government. It's only been a little bit more than 2 years. But my follow-up is, I don't know that I want you to tell the councils that I work for here yet, but one of the potential applications seemed to me, if you have land and maybe it's guided for a particular use, and you have a group of members of the community who want to take over beneficial development of certain land uses that apply to property, that might be an application for a structure that relies on them more than the simple business council, general council methodology that's currently used. And again, I probably will be in the ground if that discussion comes up. But
Because I
think
could
that's
see it
one-
being a conflict, right? Like
Yeah.
an absolute conflict with the the tribal development plan. I could see it being an absolute conflict. So is there a protection to be built in there, right? Is there a protection to be built? It's subject to tribal approval. I mean, there are things to think through like that. That's a good point.
Hi, I'm Kalika Ellefson from the Lower Elwood Tribe. And in my tribal constitution, the tribe does not take jurisdiction over individual trust lands, only as far as the reservation. So not even tribal-owned fee land is included within their jurisdiction according to the Constitution. And so I guess my question is, would the Constitution need to be amended, which requires secretarial approval and all that, in order for the community to take advantage of any of these sort of structures? Because they kind of don't have authority. Because they just never took it, like they could. Some constitutions just extend
Yeah.
authority as far as treaty rights go.
Right. So, I mean, I think that's going to depend on the extent to which the tribe participates, right? Is the tribe going to participate at all in the way that this land ownership stuff is structured? From a jurisdictional perspective, when we're talking about individual trust allotments, when we're talking about individual land interests, the tribe certainly has sovereign authority to exercise jurisdiction, right? To the extent that they don't, for whatever reason, under their constitution. Yeah, that's interesting. That's interesting.
And that's one of the things that will need to happen, is having some of this replicated at a federal level. So again, as I talk about this new class of Indian landowner being the corporate entity, I mean, we're going to look at legislative changes, because if you follow my line of reasoning, Interior operates from the Indian Reorganization Act or the Oklahoma Indian Welfare Act, and both of those statutes passed in the mid-30s show that Indians are defined as this, tribes are defined as that, and they are the only two classes of landowners that Interior will work with. And so, like I said, right now, the ownership is the piece that's missing, and that's where I think a lot of the individuals are looking at the foundation to provide some opportunities for growth and changing that trust relationship, redefining how the fiduciary responsibilities behave. And in fact, actually, we will end up coming up with some of those federal solutions, because one of the families I'm working with in Oregon, they're enrolled in some of the California tribes and Burns Paiute, And for their situation, their allotments are considered public domain. As public domain allotments, technically exists outside of the Burns Paiute jurisdiction. Now, when land defaults through AIPRA to the tribewood jurisdiction, they basically have given those interests to the Burns Paiute tribe. And so as I work with the family, they are going to have to rely on Burns Paiute tribe to come forward and do different things on their behalf. But at the same time, they can't count on that happening because legally speaking, the only one who has jurisdiction over those lands is Interior because they're public domain. They're not specifically set aside for any specific tribe, but they are set aside for the individual landowners. In California, you see some of the same thing with public domain lands where there is no specific tribe who has jurisdiction. Watch where I'm underneath those.
But it's trust land?
Yeah, this is Indian trust land.
Okay.
Like I said, both Oregon and California, it's considered Indian trust land, but
held for an individual and not associated with a tribe?
correct.
Okay.
And I know in Wisconsin, there are some public domain allotments. Minnesota has some. So it's not an exclusive problem.
Yeah, Elwha has public domain. What I do is work with families to get all their small undivided interests and then exchange it for tribal trust so that it becomes one-on-one individual for them. I've tried to ask the families to, get together and try to make their undivided interest above 5% gift conveying to each other, but that never happens. But we only have 10-acre allotments, so it's, trying everything to keep a bigger piece for them.
And that's something I didn't exactly cover very much detail, that this is a vehicle to look at consolidation of the fractional ownership. And in the long term, that's why I point out, if a corporation becomes the owner, that nonprofit, conservancy type of activity doesn't have a finite life the way I do. It could continue as long as the law allows for it to exist. And again, like I said, it becomes a way to avoid probate. It's innovative. I think as we've adapted and changed, it becomes a way for us as Indian people to use tools that are available to us when we're off the reservation. But right now, that opportunity doesn't exist for us on the reservation.
Eric Giles of the Creek Nation, and my question on the family corporate trust is, if they're being formed as an LLC or a corporate entity, what would be the law that would regulate the operation of those entities? Would it be corporate law, but maybe like the Uniform Trust Code, because they're acting in a like, if someone was to be designated the principal of the LLC, aren't they really kind of acting in the form of a trustee of the LLC? So that's just one clarification I asked.
Well, and I think it's going to depend on where the corporate entity is filed, right? So if you have the ability under tribal law to organize under tribal law, right, then it's going to be a tribal code that prevails. If you're talking about not having access to those types of structures under tribal law, going outside of tribal law and looking at state law, I don't think that you're going to get anywhere besides those two options, based on just putting together, corporate legal filings. But Jim's point about wanting tribes to kind of have that in place as an option under tribal law rather than state law, I think makes a lot of sense. I don't think it's fatal if you don't. I think if you go and incorporate under state law, it's still okay, right? But I do think there should be a preference for tribal law all the time. Because, the states oftentimes won't do anything when it comes, they have this hands-off approach, like they won't do anything when it comes to stuff that's occurring on Indian land or in regards to Indian land. So my concern would be that there would be no kind of enforcement authority available to the corporate entity, because the state law wouldn't recognize that it mattered for purposes of protections or enforcement.
And that becomes the hardest part, is whether the tribal government feels that it has the capacity. I know a number of the reservations in the Midwest don't have the financial resources to do the enforcement and monitoring, registration, tracking of their activities, because what you highlight is, if I'm designated as the president of the corporation, well, I have a fiduciary responsibility in exercising agency on behalf of my cousins and the other landowners. So what happens? Who's going to come after me if I embezzle money? Who's going to do those things? And that's a reality that I think tribal governments have to take into account when they're looking at some of these things happening.
I'm Barb Brodeen from Bois Forte, and I'm just curious how this would work for my tribe. We have 6 bands which are under the Minnesota Chippewa tribe. So we each have our own tribal constitutions, own tribal laws, but when it comes to the interior, the Minnesota Chippewa tribe is our umbrella, and that's who's recognized. So I'm curious as to how this would actually function for us. And then to complicate things even further, of the 6 bands, we are the only non-public 280. The rest of them are.
So 5 of the 6 bands are PL 280?
Yep. And,
wow.
And we are. So it's a really it's complicated, and right now the Minnesota Chippewa tribe we're in the process of returning all of the land that the Minnesota Chippewa tribe owns within all of the 6 reservations. And we can't even come to an agreement on how that is going to be done, even though, the land is within each of the 6 reservations. So I'm curious as to how this would be done within the Minnesota Chippewa tribe.
So can I ask a couple of questions as a follow-up? So when you talk about that umbrella organization, right, with each of the 6 bands, does that umbrella organization also have a constitution?
Yes, it does.
And it references the other 6, is that right? Okay.
And that entity has a tribal executive board, it consists of the 6 bands, chair and secretary treasurers.
Okay. So when you talk about there being 6 different reservations, was that how it always was? Did the reservation status come up originally as 6 separate ones and not just one reservation to that umbrella group?
No, I believe we were always underneath the Minnesota Chippewa tribe.
But with 6 separate reservations?
Yes.
So
It was an easy way for the government to take care of us.
Sure. So when we talk about that umbrella organization, is that the only federally recognized American Indian tribe, or all 6 bands separate federally recognized tribes?
All 6 are federally recognized.
Wow, that's blowing my mind. Okay. So yeah, that's a lot to have to work through to figure out how to put a structure like this in place, right?
Right, because what I can see happening and what I've seen happen all my life, I grew up on the reservation, I still live there, and I've been heavily into politics. My dad was a chair at one time, and I've seen that individual rights have always been important to people, but when you come to individual rights versus band rights, it's a big struggle, and we always have gone with band rights. And so it would be, and because we always fall under the Minnesota umbrella, it always goes to a vote with the 6 bands. I mean, we all have a vote. So it would be.
But there could be 5 against 6 in a vote, right? I mean,
Well,
so, yeah.
it would go to an individual, in this case, I think, I can see it going for individual votes. So you're talking thousands and thousands of
Yeah.
people
Yeah. Wow.
voting. So I would like to hear how you guys think we can do that.
Go ahead, Jim.
And so what you would end up doing is, no, I mean, your comments illustrate a very difficult situation. And when I think about how we could address that, I think one of the more telling things in your comments to me,
Yes, absolutely. Case
one of the more
study.
telling things in your statement, though, is that you said you were kind of suggesting that individual rights usually take a back seat to band rights, and that even band rights sometimes take a back seat to the MCT, Minnesota Chippewa Tribe rights. And so it may be a situation where your leadership would have to filter from the top down to make something like this happen, because in a lot of places I'm suggesting that it come from the ground up, and that you kind of force the government's hand, both at the tribal level and at the federal level, to take action that reflect what landowners want. And so, like I said, my gut reaction is that it's going to be a much harder solution to develop for the MCT tribes individually. It's not something that we would shy away from if we had different pieces of MCT coming to us and saying, yes, we see the value in this, we would like to see it happen. The foundation would put resources into helping navigate through the development of a solution. It's not something that we could say would happen in the next 3 months. It might take us 2 or 3 years to start to put that groundwork in place, and then maybe another 2 or 3 years to get the approvals in place so that it actually can happen. Now, the foundation has been in service since 2002. I've been in place for about 5 years. I don't see the foundation really going away. I enjoy the fact that every day I get to go and help Indian landowners and tribal communities better their situation when it comes to land ownership and management. We would be there. We would just need to make sure that the invitation is extended for us to come support that effort. I mean, so I don't have a solution today, but I think if it is important enough to MCT, we could come up with a solution that works.
I also think it highlights, right, this weird tension between individual landowners who have an interest in trying to figure out how to manage their property, but tribes having an interest in making sure that they don't do anything that messes up kind of the tribal priority. So, I mean, it really is that tension that we talked about earlier, like on a zoning and planning scale. I mean, it could just really have a lot of implications. And my thought process in working on this project has never been to create tension between the tribe and its citizens, right? So if those tensions exist, we need to know them, right? And we need to work through them. And if we can't work through them, we got to fix it, because we can't be putting individual landowners in a position to be sideways of their tribe every time they want to do something with their land interests. We just can't have that.
Yeah, absolutely.
I'm going to use your entire speech today on my law school final exam this semester. I just want you to know that. That's awesome. I didn't know anything about it.
One more thing I just wanted to say is I have the whole BIA staff that I work with. I'm the only one in my realty office, and so I have to work really closely with my BIA office. And unlike the stories I've heard during this conference, I get along really well with my BIA, all of the BIA people that I work. So, and they have been very helpful to the people that are on my reservation. They have helped, tremendously. So I just want to put that out there.
That's
So,
good. Thank you for sharing that. It's good to hear that instead of, always the other way, so. Any other thoughts or comments or questions about this?
Concerns about, a project like this in your community? Anything? Was wondering when you'd have a question.
Thanks. So I missed the first part of the presentation, but it sounded like you were talking about working with a family, and I don't know how many interests that was, 3, 5 maybe. But, looking at this and trying to do something about consolidation, what I'm seeing is tracts with, 100 owners, 200 owners, live all over the U.S.,
Yep.
live in Canada, live in, military bases. So just wondering how something like this could take off for those kinds of, highly fractionated tracts, rather than just like, one family.
Yeah, I think that's exactly what the project's aimed at trying to address, right? So I anticipate seeing those larger numbers of individuals coming together under like a corporate structure. I think that's exactly right.
Or a landowner association. Like I said, it may be a way for a landowner association. One of the advantages in those larger contexts is you have a centralized clearinghouse for exchanging information, for taking action. You have the ability as a landowner association to do a lot of the pieces that become so hard when people are spread out. They may live in other places. They're not in regular contact. So that's probably one of the beauties in looking at a formal entity coming into play for highly fractionated ownership. Again, when you're looking at the corporate structure, with votes, you can do that through the mail. You can do it online. There are ways you can get around the communication challenges for an organization with so many different voices coming together. But again, it's something that the landowners need to take responsibility for to make a change. And once they've made that decision and make the commitment of time and resources, the Indian Land Tenure Foundation would help at the beginning. And ideally, it will be something that sustains itself. I think we haven't really gotten to that final piece when Casey's talking about not relieving Interior of its fiduciary responsibilities. We had a number of conversations internally and then with Interior, and we keep saying back and forth with Interior because we did have the Office of Special Trustee, we did have solicitors, we did have BIA coming to the conversation, and each of them has a different perspective on what this might look like in their bubble, even though we all work with Indian land. And so when we're looking at how this thing could work, where was I headed with that? That we want to see more freedom for the landowners to take action. We had, when we were going through the conversation, trying to figure out, well, how do you protect the landowners so that Interior is not giving up its fiduciary responsibilities, and allow the families through these corporate entities to exercise rights of leasing, to collect money in and of itself and disperse money in and of itself, not going through the formal process of drop boxes and IIM accounts. So there's a lot of things that would need to go into place, and that's where it's going to take legislative changes, not just at a tribal government level, but at the federal government level as well, because all of those things don't exist. And like I said, some of it is actually not legal. It's not that it's illegal, it's just not legal to do it because they don't have a map for how that would work.
That's right.
No.
I'm wondering, like, there's just so many apathetic landowners, that own the 0.006%, 0.0005, whatever. And, why would they open up this piece of mail that looks even more complicated than OST's mail that's also already complicated? So how would you get them involved, when they have that and just, okay, I'm going to get 5 cents and maybe it'll be 10 cents next year. with this new structure. So I just wondering how to get those landowners involved.
Yeah, I think there'd have to be a strategy for that. Yeah, I mean, I think the group's gonna have to figure out how that works, and whether it's asking those folks to sell their interests, whether it's asking those folks to just give a broad-based, year-long delegation of authority so that they don't have to bother with responding to mail every time it comes in the door. I mean, there are different ways to strategize with that, but it has to be addressed.
I think acquiring the interest from the apathetic landowners becomes the easiest way, but that's where no single organization is going to be able to get those apathetic landowners involved. It's going to be family members calling them out. It's going to be finding ways to get them to realize their power. When I talk about individual allotments and you've got highly fractionated, sometimes all you need is 50.001% to speak with that one voice, and you exercise control. So it becomes a way to kind of bypass the apathetic landowners, because you've got enough people who realize why this is important, why this action is going to take place. And sometimes it comes down to just exercising a veto power. Here in the Midwest, there's a lot of movement by landowners to stop pipelines from going through. So for them, it might be just getting that extra vote at the table and going to the superintendent and saying, we don't want this through our land. But you have to have enough activity going on so that those people realize how they exercise their voice, how they can get involved in the process. I can tell you, having worked for tribes, that I would assume that we'd have a lot of people participate in a conversation and nobody would show up. I'd have 2 or 3 people who are at all the meetings, and we'd have a great conversation because, we'd pick up the things we talked about a month ago, 3 months ago. But I can guarantee you, when something is going to happen that they don't want, they'll get their butt in the seat. They will show up at meetings and they will make sure that they're heard. So like I said, with the agricultural co-op and the Alati Association down at San Javier, it was a fact that they had lost water rights. So they came together and they were able to use that to create the momentum that now, 25 years later, they still have these organizations in place. But it took something so dramatic to get them to focus and work together. So I can't say that there's going to be a magic bullet. My voice, my conversation with you today is really to illustrate that these are things that we need to do for our tribal communities and allow landowners the ability to take on these opportunities when they present themselves, to fight the challenges, because right now our governments aren't set up to allow those flexible tools to the landowners, and create the avenues for families to do with their land what they really would like to do. Like I said, sometimes it's as simple as just working together so that you can build houses for yourselves, generate revenue that you might use to provide scholarships to your family members.
I just want to add to that. This is Patty Olby again, Minnesota agency. So just to clarify, a land transaction wouldn't be approved by the superintendent or anyone at the Bureau without the required consent. So like if a landowner remained silent, we wouldn't say, oh, we think they said yes. We need their consents. So nothing would be approved until we have that 50 plus, in some cases on the highly fractionated lands, consent. So I just wanted to throw that out there.
Sure. And, thinking through how to have the authority of a new organizational structure recognized by the department, that's one of the biggest sticking points that we ran into, because the whole idea of doing this is to have one voice that represents a whole lot of folks, right? But recognizing that one person, that one representative, that entity could speak on behalf of all of those folks, papering up documentation that demonstrated consent became a very important conversation. And I think that might have been where we all decided we were going to just go eat because it was too hard to get through, right? Yeah. Thank you for that.
Yeah, my name's Anita Matt. I'm with the Confederated Salish Kootenai Tribes in Northwest Montana. I'm on the tribal council now, but I used to work as a realty manager. One of the things we ran into was finding the owner, especially where the land had been transferred into non-Indian. And of course, with Cobell and everything, we're all of us are enrolled, so there's a way of finding us, but we couldn't find the fee owners. So when you're looking at that 50%, that was my question about what other tribes are doing about finding that twice inherited land out to non-members.
So when you're talking about fee ownership, we had a little bit of discussion in our session before lunch about this, because it is just a big problem, right? When you're trying to run down records that aren't going to be at the Bureau, they're not going to be at the tribe, they're not going to be in individual families, right? So you get stuck in this weird, like, land research quagmire where you're going to the county and looking for stuff and they don't have it either, you know? I mean, you just don't have the right kinds of documentation that you might expect that you'd find if it had never been in trust or if it had always stayed in trust, right? So Jim had a couple of recommendations for just, you know, kind of doing what you can to document what you can find now and going back as far as you can go and making sure that you paper it up so that when additional parcels fall out of trust status, there's at least some documentation on it, right? But as for stuff that's just missing, it's missing. Can you-
Oh, absolutely.
Sorry, I didn't hear
She
her.
said that trying to keep it in trust, that,
Yeah.
I don't know that I'm quite explaining it well.
What I'm saying is it could have stayed in trust just in a non-member's name under AIPRA.
Sure.
But it's just finding them, and sometimes there's just no finding that individual.
Can't find the person who is benefiting from a life estate, for instance. Yeah. I assume that there would be, I mean, you can always go through the probate record to try to see if there was any documentation of an address in that instance. Or, you know, you can ask that the person be added to the ever-growing list of folks whose whereabouts are unknown, right? Try to track people down that way. You know, I mean, I've seen some communities actually hire private investigators to go find individuals at their own cost. That costs money and it doesn't guarantee you're going to find people. But I think you can find just about everyone on Facebook, so I might recommend Facebook.
Thank you. Tim LaPointe, Bureau of Indian Affairs. Had a couple of questions. Number one, can you tell us where the 30 pilot places are? Are there 30? I think the statute said up to 30. And then secondly, how is environmental compliance contemplated? Is it, because I know NEPA is a factor, especially historic preservation should be an issue too. Thank you.
You want to take the first one? I'll take the second one.
The 30 does not exist. Interior was more than happy to let us run, how did I refer to this? We did not do a pilot project because under federal law, they have to have the regulations first. So what the Indian Land Tenure Foundation was able to do as a public entity is to do a research project. So the activities that I'm conducting are for policy development and advocacy work. We're not actually doing the pilot project, especially from a legal context. And we're going to use that information to instruct how Interior might approach this. We had, like I said, we had the head of, well, one of the top officials with OST. We also met with some of the folks higher up in the BIA on these projects to let them know kind of what we were thinking, and again, find from them what were some of the pitfalls and opportunities they foresaw with a project like this. Ultimately, I think what we're looking at is probably some of the families who've made significant progress and advocating that those tribal communities become some of those 30. You may find some of the other tribes who exercise their political clout to become part of that 30. But at today, there's nothing specifically going on at Interior to actually make this happen. It continues to be policy development and advocacy work at the foundation.
Okay, so I'll talk about environmental regulation. So when we think about land ownership, right, it doesn't matter who owns a piece of property. Environmental regulation is going to take effect as to that property depending on who has the jurisdictional authority to exercise environmental control. So whether or not title remains in the name of an individual Indian beneficiary, or if title is instead transferred to a corporation or some other structure, it's not going to change who has the regulatory authority on environmental issues as to a particular piece of property, right? But I think it's a very good observation to think about making sure that folks understand which rules apply to them. And that's a very difficult analysis in Indian country, right? When we start to wonder about who has the environmental regulatory control, it's going to depend on which state you're in, which tribal community you're in which state, because there are different federal laws that change what tribes have civil regulatory authority over and what the federal government continues to maintain environmental regulatory authority over. So it's definitely a community by community analysis, but would not be changed by a transfer in ownership.
So my question on the 50%, when you create one of these entities formed under a tribal LLC code, under tribal law, that entity is considered a person. So if under tribal law, this entity is a person, doesn't that make that requirement to have all, and that person represents 50% plus of all the fractionated interests in that land? Why then, if they're going to enter into a long-term lease or do some other encumbrance or whatever, that they would need to get the Bureau's approval of all 51 individual landowners when this entity itself is a person under tribal law? Wouldn't the Bureau need to default to tribal law and what its application is?
So that would be the goal of it, right?
Yeah.
I mean, it would be the goal that the Bureau recognize the authority of that representative entity to speak on behalf of everyone who's represented by the entity.
Yeah.
That'd be the goal.
Okay.
How do we get there?
Yeah, that's what doesn't the BIA have to defer to tribal law for other leases regarding land use? They have to, if there's a tribal code on zoning or something like that, then the BIA has to uphold those codes. So I would just think it would be the same thing here if an entity was formed under the tribal LLC code or corporate code. It's now a person representing the membership, 50% plus owners.
Mm-hmm.
I don't know if there's any comment about that.
Before we get into the finer details of that, let me kind of throw in that when you look at owner-managed interest, which is also introduced with the American Indian Probate Reform Act, AIPRA contemplated owner-managed interests. With the folks that we were talking about, they called it the family farm. But if you actually got an OMI agreement put in place, it requires that you get 100% of the owners to participate in the process, at which point it starts to allow some of these things to progress. I would see it probably behaving in a similar fashion that, you couldn't just pull 50% of the landowners in to an entity then to control the whole parcel.
Right.
You would have to have 100% of the owners signing on to that activity for them to exercise over the whole property. So with this one, when I'm looking at it, that's why we specifically talk about a veto power. It becomes a way to exercise all those voices in unison rather than, and that's specific to management. It's not really to ownership. I don't know. Did you have other comments with the various capacities?
I don't know if I agree with that.
With what I just said?
Yeah, I'm pondering it.
Okay.
I'm going to reserve the right to say something else in a few minutes after my brain buffers that through.
Thank you. Again, earlier in the presentation, you talked about the need to convince tribal entities to develop regulations that would allow these kinds of structures. My concern about that is not necessarily getting the tribal governments to develop them, but the potential hangup is that they then go to the BIA, which says, by the way, you haven't provided enough protection against fractionation of these lands. And by the way, there are processes in your ordinance that we disagree with, and so you can't implement it anyway. And I'm thinking to a time that the tribe I work for went through that I wasn't present for. They finally got a Hearth Act lease ordinance, but it didn't happen the first time through.
That's definitely something to plan for. Potential delays in secretarial approval when it's required. Keep in mind that those AIPRA provisions for tribal code approvals at the Department of Interior apply to probate codes. So if we're talking about anything other than a probate code, it's going to be subject to secretarial approval if the tribal government's own organic documents require secretarial approval for codes, ordinances, or constitutional amendments. So unfortunately, more than not have to go through some secretarial approval, but not all. So maybe we start looking at those tribes that don't have that same block. Jim, over here.
Patty Olby here again. I'm having a hard time just wrapping my head around this idea. I think it would be great as a BIA approving official to just receive that one voice to make a transaction work. But one of the problems that we have, of course, is with ownership. It's so volatile. And how would you manage that in the membership of this organization who's going to represent this family who's always going to be changing as there are new heirs and gift conveyances? I mean, I don't understand that. And
So I think there's not a clear answer to that right now. But if we are able to effectuate the title of the property actually being in the name of an entity rather than an individual. An entity, as Jim mentioned earlier, can exist into perpetuity, right? And so you can actually establish ownership interests in the entity rather than in the real property. And those can be governed, governed like any kind of like corporate share might be, right? You can nominate beneficiaries on corporate shares. You can leave them to people in your wills, right? So I think switching the idea from ownership of a real property interest to ownership of a business interest is really kind of where that leads us in that analysis.
And one of the conversations I have with families and co-owner groups when I meet with them on this topic is for them to think about those issues. When you look at a corporation, I mean, you issue more shares, you issue more shares. Well, how is that any different than fractional ownership in it is as it exists today? Are you just perpetuating and then now moving the onus of highly fractionated ownership from Interior on and making it a burden of the family? And so when I go through that with families, I say you need to think about, how do you want to have people participate in this process? It's easy today if you're only talking about, maybe this generation, which is 7 brothers and sisters, and the next generation, which is, let me think, say 16 or 17 nieces and nephews or cousins all together. I mean, it's a very small number in the grand scheme of things, but 50 years from now, how is that going to look? You might have so many shares. So when I talk about, maybe 7 patriarchs and matriarchs who set up the original structure, maybe you only end up with a total of, say, 21 ownership shares. Well, at some point, you're going to have to make a hard decision that somebody's going to get left out of the picture. If that's not tenable to you guys as a family, you have to come up with a solution on how to address that. Because at some point, if you don't make the hard decision today, like I said, you're just going to be facing, highly fractionated ownership inside your structure 50 years from now. So when it comes to addressing how do you make those decisions, it's the family who's going to make that decision. It's the landowners who decide how are people going to participate in the process? How are they going to have a vote? How does that vote transfer from me to my daughters? How does it transfer from, my brother to his kids? Those kinds of things are integral to those earliest conversations so that they start to think through, because at some point when you create entity, you have to put that into your bylaws. So I get to cop out and say I don't have to come up with an answer, because ultimately I provide options to the families and they have to develop the answer that works for them. And it may not work 50 years from now, but if you create your charter and bylaws to allow for changes, well, maybe those family members decide it's worth it to, make sure that my kids, because I'm second generation, so my kids aren't going to be part of it, because when Grandma and Grandpa put it together, there were only a total of 21 shares. My kids can't get it because I'm one of 21. So it is going to be one of the hardest discussions, I think, for families when they look through this.
I mean, I think if we can get to the point where an entity can be listed as the owner of the beneficial interest on the property, it definitely achieves the objective of AIPRA to stop fractionation, right? Because once we get the ownership there, it never changes again, right? Assuming no dissolution of a entity structure or something. So, I mean, it does achieve one of the purposes of AIPRA, but I do think, there are just a whole lot of things to think about in moving forward with putting something together. And thinking about it from both the individual perspective, the tribal perspective, the federal perspective, right? How it could work, but there has to be a way for it to work. We just got to figure it out. There has to be a way for it to work to make it easier on everyone.
And that's why I like these discussions, is these are the things that I don't see enough of, or here, actually, these are the kind of discussions that I'm sure do occur in DC, but we don't get the benefit of hearing how those conversations take place. And again, most of what I have seen as a result of those conversations are ways that make it easy for Interior to manage the process, not for the landowners. So your participation today, me working with families, allows us to hear what is important on the user side and make recommendations. Looks like everyone's packing up. Oh yes, it's 3 o'clock. So
Thank you guys for your attention. There's another session at 3:30.
thank you.